today.
This is. Oh, yes.
May I release your lordship? Lordship, I am representing the respondent number 2, my lordship. This honorable court passed an order 06/04/2025. Behind my back, my lordship. Lordship, with profound respect, my lordship, this honorable court leaves a question: does the living relationship partner can claim maintenance? That is the question, substantive question of law, my lordship. So, my lordship, my first humble submission.
No, we are ready. Both are ready for hearing.
Lordship, date may be fixed, my lord, because they have filed the affidavit, my lord, of course, and they have appeared today.
Why, on what ground you have filed this criminal petition?
Yes, my lord. First of all, my lord, lordship may kindly see.
Live-in relationship.
Yes, but this is of course not, my lord. Lordship may kindly see page number 12. It is the complaint filed by the respondent number 2 before the family court, my lord, seeking maintenance, my lord. Seeking maintenance.
Page number?
Page number 12. It is the petition filed by the respondent number 2. Before
Yes.
the learned family court, my lord.
Yes.
Dairy, my lord.
No, what do you want to show?
Lordship, basically, the thing is that the respondent number 2, Lordship may kindly, I would like to point out paragraph number 2 first of all. Paragraph number 2, because my name is Abhijit Ghosh. Abhijit Ghosh. And that respondent number 2, my lord, Lordship may find at page number 2, I mean, para number 2,
Yes.
that a male child already born to her out of some relation between one Mr. Sunny Go. Then thereafter, my lord, the maintenance case has been filed against me.
Why?
Lordship, may I respond that?
No, then what is the
Then, my
allegation
lord,
against you?
Then, my lord, then, my lord, paragraph number 4, my lord, that is against me, my lord. That the petitioner begs to state that on 15/11/23,
So she cohabited with you later on.
that is the averment in the complaint, my lord. But this is not the fact, my lord. My lord,
No, fact will be decided by the trial court.
my lord, the prima facie, my lord, the petition, my lord, does not disclose the place of cohabitation, my lord. And moreover, my lord, the affidavit filed by them, because the lordship knows that shared household has to be there for basic parameter of living relation is the shared household, my lord, and domestic relation, my lord, between the partners, my lord. Now, lordship may kindly see the affidavit filed by them. There are some text messages at page 27 onwards, my lord.
No, on what ground you have filed the criminal petition?
My ground is that this is not a living relation in the nature of marriage, my lord. Only living relation in the nature of marriage, one can claim maintenance from the other partner, my lord.
But that plea you can take before the trial court. That plea that it is not living relationship in the nature of marriage.
My
Whether this court will sit as trial court.
No, my lord, but I have approached, my lord, because on the face of the record, my lord, the complaint petition does not disclose that they are in a living relation in the nature of marriage, my lord. And lordship may kindly see for a moment, my lord, page number 28 onwards. There are some text messages through mobile, my lord, Instagram. That itself proves that they are not sharing a shared household, my lord. Their conversation only phone.
What is the requirement of a living relationship?
Yes, my
live
lord.
in.
Lordship, I would like to rely the judgment of the Velusamy, my lord.
Where are the text messages?
Lordship, their affidavit, my lord.
Page number?
Affidavit filed by them at page 27 onwards, my lord. Page 27. Of course, it appears that there is a love relation between the persons, my lord. But
What do you want to show by showing this?
my lord,
And they are not staying in a
together.
same.
Of course, they are not staying together. They are not having any shared household, my lord. This is one of the parameters, my lord, of living relation, my lord. But
No, you-
and the thing,
Suppose somebody takes to each other. Is it sufficient to come to a conclusion that they are not staying together?
that is why I am placing, my lord, that judgment, my lordship, may kindly see there are 31 of the judgment, my lord.
Velusamy.
Yes,
Velusamy.
last page. There are 31. In our opinion, relationship in the nature of marriage is akin to a common law marriage. Common law marriages require that although not being formally married, the couple must hold themselves out to society as being akin to spouses. They must be of legal age to marry. They must be otherwise qualified to enter into a legal marriage, including being unmarried. But she is married, my lord. They must have voluntarily cohabited and held themselves out of the world as being akin to spouses for a significant period of time. Next, my lord, in our opinion, a relationship in the nature of marriage under the 2005 Act, Domestic Violence Act, my lord, must also fulfill the above requirements. And in addition, the parties must have lived together in a shared household as defined in Section 2S of the Act. Merely spending weekends together or a night stand would not make it a domestic relationship. Because they must have a shared household value. And their affidavits is showing that.
This proceeding is under 125.
Yes. 144 now under BNS. Lordship, I would like to point out that in this case, my lord, in the judgment, another judgment has been referred to. Lordship, may kindly see para 11. This is, my lord, in Bimala versus Biraswamy. Who can claim maintenance under Section 125, my lord? That is there, my lord. The definition of wife is also there.
Yes, read.
In Bimala versus Biraswamy, the three-judge bench of this court held that Section 125 of the Code of 1973 is meant to achieve a social purpose, and the object is to prevent vagrancy and destitution. Explaining the meaning of the word wife, the court held within quote, the object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelter to the deserted wife. When an attempt is made by the husband to negate the claim of the neglected wife, depicting her as a kept mistress on the specious plea that he was already married, the court would insist on strict proof of earlier marriage. The term wife in Section 125 of the Code of Criminal Procedure includes a woman who has been divorced by a husband or who has been obtained a divorce from her husband and has not remarried. The woman not having a legal status of a married wife is thus brought within the inclusive definition of the term wife, consistent with the objective. However, under a law, a second wife whose marriage is void on account of the survival of the first marriage is not a legally wedded wife and is therefore not entitled to maintenance under this provision. Facts are very clear, my lord, in this case, my lord. She should have, my lord, claimed the maintenance from that Mr. Sony Group, my lord. And to them,
No, to him also she was not married.
of course, my lord, but she was having a child with him, my lord. He's having a child. The basic thing is that, my lord, the affidavit filed by them only shows that they are in a distant relationship. Of course, there might be some love relationship, my lord, but living relationship is not there in the nature of marriage, my lord. The text showing that, my lord. Shared household is a basic parameter, my lord.
Lester, may I make my submission? So, Lester, my first objection regarding my learned friend saying that she should have claimed maintenance from the first. As per the section 125 CRPC and 144 of BNSS, my lordship, only she could have claimed maintenance from the first husband or boyfriend, whatever it might be, if she could not have second relationship. If he entered in a second relationship, cohabited the second guy, how could she again claim maintenance from the past? That is impermissible under law, my lordship. And second thing, my lordship, with due respect to my learned friend said that in the text message and in the photograph, it shows that there's distance couple, my lordship. Lordship, my respectful submission before your lordship is this. Just because of they have related some text through the messages, that cannot be tantamount they are in distant relationship. And second thing before your lordship is the photograph itself shows they are together. And in their petition, my lordship, with due respect to my learned friend, they have stated in their petition that there are no tasks about. They are not even. It is seems like that even no one does not know on another. But in my petition, my lordship, where I have demonstrated, they have photos together, they have text message together, which basically confirm, my lordship, that yes, and either it is in the nature of relationship can be tantamount to be living relationship. That part I will leave at your lordship should be decided by the trial court at the first instance, my lordship. And second thing before your lordship is that my learned friend relied to judgment. I would like to relate 3 more judgment of the Honorable Supreme Court. This cannot be a blanket ban, my lordship. It must be decided particular facts and circumstances. What the Honorable Trial Court will look into the facts, evidence, and all this together. If all this putting together can reliable, then they can be decided the maintenance and the living relationship are not. But under section 125,
What is the corresponding provision of section 125 in BNSS?
on 44 BNSS, my lordship. Lordship, may I make 3 more?
Yes, just a minute.
My learned here in this proceeding, my lordship, criminal quashing petition, though I am going to rely on Honorable Supreme Court judgment, when Honorable this court can quash a petition, before that, my lordship, I would like to point out 2 more things, my lordship. Lordship, here my learned friend burden is more than me, because here he come to quash the entire criminal proceeding before the family court, my lordship. My burden on me before your lordship is this one: show a prima facie relationship them, and their job is to either their statement must be.
What is live-in relationship?
Live-in relationship, basically relationship if the man and woman are lived under the same household together, they have mutually lived together without any force and coercion in the same household, and that must be in this. They understand it, not that they have to live together all the time. They might go somewhere else for work, then again come together, then again go. It is just like family, husband and wife, they live. Suppose, my lordship, I'm giving an example.
Any authority is there where it has been?
Yes, my lordship.
As to what is living
Yes, my lordship.
relationship?
Yes, my lordship. There are observations on our Supreme Court. I am placing a judgment before your lordship. Kindly look into my lordship, my judgment. This no lordship, exhaustive part, my lordship.
Which judgment?
Lordship. Lordship. My Lordship, Inder Sharma versus BKB Sharma, 2023. Lordship, kindly look into the paragraph 52, my Lordship. Here from 55, my Lordship, I have annexed it.
No, just a minute. Have you provided that?
Yes, judgment I have provided.
Pradeep Kumar.
Paragraph 55, my Lordship.
Yes.
Lordship, may I read, my Lordship?
Para 55.
Yes, my Lordship.
Yes.
We may, on the basis of above discussion, call out some guideline for testing under what circumstances a living relationship will fall within the expression relationship in the nature of marriage under section 2 close bracket F of the Domestic Violence Act, my Lordship. The guidelines, of course, are not exhaustive. That means it cannot be exhaustive. There might be more ground that can be included under facts and circumstances will be decided, my Lordship. But will definitely give some insight as such relationship. A duration of period relationship section 2 close bracket of the Domestic Violence Act has used the expression at any point of time, which means a reasonable period of time to maintain and continue a relationship which may vary from case to case, depending upon the facts and situation, my Lordship. Second, my Lordship, shared household. The expression has been defined under section 2 close bracket S of the Domestic Violence Act and hence need no further elaboration. Third, my Lordship, pooling and of resources and financial arrangement of supporting each other or any one of them financially sharing bank account, acquiring immovable properties in joint name or in the name of women, long-term investment in businesses, shares in separate and joint name, so as to have a long-standing relationship or maybe guiding factor. Domestic arrangement entrusting the responsibility especially on the woman to run the home, do the household activities like cleaning, cooking, maintaining or upkeeping the house, etc. in an indication of a relationship in the nature of marriage. Sexual relationship, marriage-like relationship refers to sexual relationship not just for pleasure but for emotional and intimate relationship, for procreation of children, so as to give emotional support, companionship and also material affection, caring, etc. Children of having children is a strong indication of a relationship in the nature of marriage. Parties therefore intend to have a long-standing relationship. Sharing the responsibility for bringing up, supporting them is also a strong indication. Socialization in public, holding out to the public and socializing with friends, relation and others. If their husband and wife is strong circumstances to hold the relationship is in the nature of marriage. Intention and conduct of the parties, common intention of parties as to what their relationship is to be banned, be and involved, as their respective roles and responsibilities primarily determine the nature of relationship. May I please your Lordship one more fact, my Lordship? Lordship, these are not, all need not to be affirmative. It might be 3 conditions satisfied or 4 conditions satisfied. Honorable trial court will decide, seeing the facts and circumstances each and particular case, my Lordship. My humble submission before your Lordship may only interfere if it is substantive question of law, my Lordship. At this present case, my Lordship, just has been FC criminal case registered before the family court, my Lordship. Let whatever the plea my learned friend wants to make, let him make his plea before the trial court. If the trial court found out all the facts are wrong, all the facts are not sterling, honorable trial court will decide the matter, my Lordship. That is my submission, my Lordship. In fact, I am going to rely one more, two more judgment if the time permits, my Lordship.
On what point?
My Lordship, in fact, my learned friend quashing the petition under 528 itself is not sustainable under law, my Lordship. I am going to rely on the judgment of the Supreme Court, my Lordship.
Which case?
My Lordship, I have submitted for Lord Pradeep Kumar Keshwarani versus State of Assam, Uttar Pradesh, and others respondent, my Lordship. I would like to point out few things before your Lordship. When Honorable High Court will decide to quash a criminal proceeding, my Lordship, ordinarily it must not be exhaustive. Ultimately, Honorable Court will decide, but there are some guidelines given, my Lordship.
Para,
my Lordship. Para 20, I think, my Lordship. 20, my Lordship. May I read, my Lord? Page number 13, my Lordship.
yes.
Lordship. The following step should ordinarily determine the veracity of a prayer for quashing raised by an accused by invoking the power vested in the High Court under Section 482 CRPC, which is squarely will be applicable to 528 of BNSS, my Lordship. Step 1. Whether the material relied upon by the accused is sound reasonable and indubitable. That means the material is of sterling and impeccable quality. Second, step 2, whether the material relied upon by the accused would rule out the assertion contained in the charges leveled against the accused. That means the material is sufficient to reject and overrule the factual assertion contained in the complaint. That means the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusations as false. Third, my lordship. Step 3, whether the material relied upon by the accused has not been refuted by the prosecution/complainant and or the material is such that it cannot be justifiably refuted by prosecution/complainant. Fourth, my lordship. Step 4, whether proceeding with the trial would result in the abuse of process of court would serve the end of justice. If, my lord, this is very important, my lordship, if the answer to all the steps is in affirmative, that means, my lordship, all the 1, 2, 3, 4 must be in the affirmative, that all must be fulfilled, then can be honorable High Court will be quash this proceeding. Judicial conscience of the High Court should persuade it to quash such criminal proceeding. In exercise of power vested in it under section 42 of CRPC, such exercise of power, besides doing justice to the accused, would save precious court of time, which should otherwise is wasted in holding such trial as well as the proceeding arising thereof, especially when it is clear that the same would not conclude the conviction of the accused. So basically, my lordship, honorable Supreme Court says that even my friend shows the impeccable sterling that nothing has ever shown. Here I have photographs from textbooks. So I think, my lordship, with profound respect, that I made out a prima facie case, my lordship. Yes, their relationship, either it was a live-in relationship or not live-in relationship, reasonable time to test it together or not, either they have cohabited together or not, my lordship, either they have bank account either together or not, either same household live together or not, everything, my lordship, will be facts, my lordship. All these facts, my lordship, should and must be decided by honorable trial court, my lordship.
Anything?
Basically, I am on the point, my lord, the domestic relation, my lord, and the shared household. The complaint does not reflect that basic parameter, my lord. The domestic
But
relation.
shared household is relevant if we are dealing with a proceeding under DV Act. In this, the proceeding is under
No, but
DNSS.
that will come into play, my lord, because, my lord,
Because relief of
this
shares.
concept, my lord. Now this is the new concept, my lord, live-in relationship, my lord. So that is why, my lord, that will be applicable, my lord, because the judgment I have relied upon, my lord, that is reflected.
That judgment is also in respect of a case under domestic
125.
125.
125.
Lordship, may I make a final submission, my lordship?
No,
Lordship,
no. Which point do you want to say?
Lordship, I would like to point out this concept of live-in relationship in my respectful submission before your lordship, that it must not be interpreted literally, my lordship. Time and attitude have been changing, my lordship, and so our constitution is a dynamic and changing constitution, my lordship. So this is an evolving jurisprudence, my lordship, and it is an evolutionary and teleological concept, my lordship. It must serve the time, my lordship. So that is, my lordship, I would like to point out.
Is heard Mr. T. Kolita, learned counsel for the petitioner. Also heard Mr.
R. Amin, my lordship.
R. Amin, learned counsel for the respondent. State is also made party.
Yeah,
Why? State is not before the trial court.
Well, this is a criminal petition that we have to make them party, my lord.
Also heard Mr. K. Bosho, learned additional public prosecutor. Hearing concluded, judgment reserved. I am reserving the judgment.
Typical plus, my lordship.
Are you asking me?